Afternoon or good morning, whatever time zone you're in. I'd like to thank everyone for being a participant of our webinar today. My name is Candy Chambers, and I am with Direct Employers Association. And I want to tell you right off the bat, before we even get into our housekeeping tips, we have a huge audience today, so I know there will probably be some audio issues as you're trying to get logged in and everything, because so many people are getting on to the webinar at the same time. So sit tight. You will have audio reception very soon. So I'll read through what you need to do in case you have a problem, but just be patient. If you do have any WebEx issues, though, you can email Casey at Direct Employers, and that's KACIE at directemployers.org. If you have trouble with audio, there's a request phone button on the event panel, so please do that, and it will give you all the information to call in with your phone. As I said, we have a huge audience today, so everyone will be muted. Can't speak out loud, or we'd have a page, I think. Questions, as always, can be asked in the question and answer and chat sections of WebEx, and just make sure that you address all your questions to all panelists. These will be read aloud and answered at the end of the session. Try to keep your legal questions for your own legal counsel. This is not a legal type webinar, so just so you know that. Session has already been approved for both HRCI and SHRM credits, so if you need that credit, again, please just email Casey at directemployers.org. And the webinar and the slides will be recorded and available in the pipeline, which is for Direct Employers members only, and you can access it at voice.directemployers.org. And as always, if you want regular compliance updates, the group gets bigger and bigger, and we love it, text the word compliance to 55678. And if you want to read anything during the webinar, use hashtag DEChat. And that's it. And I'm going to now introduce a dear friend of mine, Beth Ronnenburg, who is actually president of Berkshire Associates and oversees all the business interests and operations for Berkshire. She actually did my affirmative action plans at my last organization, so she's a recognized industry compliance expert, and she gives presentations to her own clients and at various conferences across the country. She's involved in the National ILG board, and I'm sure will be involved in the planning for the upcoming conference. So as things go, it's a new year, and with the new year comes new compliance expectations, and federal contractors obviously have to be proactive in all of their approaches to the requirements and any new proposals or recommendations or regulations that come down the pike. And so I'm going to talk about the current regulatory agenda for the year ahead, policies that impact all of us, and how you can prepare for what's to come. This will be kind of fun, but the potential impact of the election year will also be discussed, and she's going to take at an anticipated audit enforcement trend for 2016. So cover how OSCCP is analyzing affirmative action plans after a full year under the new regulations, fall 2015 regulatory agenda, and what to look for in 2016. Regulatory changes that we've heard about, including gender identity, pay transparency, and paid sick leave. And as I said, the impact of the election year on federal contractors and the predicted audit focus for 2016. And without further ado, I would like to again thank Beth Ronnenburg for taking this on. She's part of our Compliance Advisory Board, and she's been a dear friend of mine for several years. So, Beth, it's all yours.
Thank you very much. I appreciate it. I appreciate Direct Employers having me come speak to their members, as well as I believe some of our clients are on the webinar as well. So welcome, everybody. And so we are going to talk about New Year, New Compliance, what to expect in 2016. So looking at the Candy just sort of went over that for me, so don't need to repeat it. The one thing I do want to say as we go through this, we have an hour today, and I am going to try very hard to leave time at the end for questions. So just so you know, I could probably spend an hour on each one of these things we're going to talk about. And so this is really just designed to give you a quick update on what's going on, what to look out for, and certainly when I know of other resources in the area, or their webinars that expand on this topic, I'll certainly let you guys know that. To get started, I really wanted to kick off with our, for most contractors, we know we do over close to 7,000 plans a year, and I'd say probably close to 6% of those are January 1 affirmative action plans, so everybody loves that date. So many of you on the call are really going into your first full year of compliance for 503 and VEVRA. And so this would be the first time that you would be audited under the new plans, requiring now the new requirements. So that includes the applicant hiring data collection for protected veterans and individual disabilities. And so I will be using the PV and IWD abbreviation as we go through. The IWD utilization analysis. I believe you did set your hiring benchmark in your first AAP. That did change to 7% as of April 21st, 2015. I think the one that will probably be the most time-consuming for contractors is going to be the annual written outreach and recruitment evaluation. And the reason I bring that one up particularly is because we don't necessarily have a prescribed format that the OFCCP is expecting. We know that they have the evaluation criteria that they're expecting you to look at, but we don't necessarily know how detailed they're expecting us to get. I did take a minute to go to their website today and look at their sample AAP to see, and actually the only sample AAP that they have out there is in the transition year. So their description of their analysis, their written outreach and recruitment evaluation, is not completed because it was for the transition year. So I do believe that it's going to be something that the OFCCP is starting to become more stringent on. So we have had a couple of clients come under audit that were in their first full year of compliance. And so they did have to do the annual written outreach and recruitment evaluation. And I would say what they submitted was accepted by the OFCCP. What I'm anticipating is going to happen is that this is going to be phased in, and is that the OFCCP starts to see more responses from contractors. They might see certain responses that they like better, and then may start requiring other contractors to add more information to their evaluation. I think it's just going to be one of those things that we're going to see evolve over time in terms of what it is that they're expecting to be seeing from contractors related to that written outreach and recruitment evaluation. One of the things I do want to sort of caution you on as we go through this is a lot of people that I talk to have, immediately gone to, well, how am I going to be able to evaluate if I don't know for sure where my applicants are coming from? So they're selecting their referral source, and I think a lot of focus is on looking at numerics. Well, how do I get the numbers to match? And one of the things that you have to know is numbers is just part of your evaluation. It doesn't have to be all about numbers. It can be more subjective when you're looking at these evaluations. So that's just something to keep in mind. You can get into analysis paralysis related to this and trying to run the numbers 27 different ways, but it may just be sort of common sense going in and looking at those sources and making a determination whether or not you feel like they provided value to you and your organization. So as you go into your first full year, again, I think we sort of are going to be eased into this, but the expectation, I believe, is only going to get greater and greater each year that we're in compliance with these new regulations. So in terms of the OFCCP's fall 2015 regulatory agenda, so they do release about every 6 months. They do it in the fall and the spring, their regulatory agenda, and giving you an update on where things stand. So the three that were on their agenda this year were in the fall was the revision to the sex discrimination guidelines, the e-pay report, and revision to construction contractors' affirmative action requirements. So go ahead and talk through sex discrimination guidelines. So that is now in what we call final rule stage. So it was proposed, contractors were able to provide their guidance to OMB. I did anticipate that the release was going to be December 2015. So now I like to say they are overdue. There was a lot of chatter that they were going to be coming out closer to December. So I'm not sure what's going on with them now, but we have not seen them come out yet. So guidelines, they really are there to, so just to say, have not been updated for over 40 years. So this is something that definitely needed to happen. And so the new guidelines really aim to address current workplace issues such as discrimination, sexual harassment, workplace accommodations, and family caregiving discrimination. So these guidelines are in terms of what it is that they are looking to accomplish. What we feel the main takeaway from these guidelines is really that OFCCP is linked to what we call codify pay discrimination concepts to allow for broader investigations. So these guidelines are going to give, again, I'm not, thank you, Candy, for saying keep your legal questions to a minimum because I am not a lawyer. But from what I hear from lawyers talking is that by codifying some of this language, it really gives the OFCCP more teeth. And so what I think the contractor community is most concerned about is that they could start to follow some of the trends that we're seeing that are occurring in California with the California Equal Pay Law. I'm sure those of you who are California employers are well aware of what that is. That went into effect on January 1st. Those of you who are not, essentially California Pay Act really expanded upon the Equal Pay Act in Title VII in terms of pay discrimination. And so they really expanded on it a couple of different ways. The first way is that they expanded the term from equal work to substantially similar work. So now they're saying that employees can be combined even if they do not hold the same or substantially equal. It has to be substantially similar. And that's when viewed as a composite of skill, effort, and responsibility and performed under similar working conditions. So it broadens that comparator, whereas I think before we would say, well, if they're not in the same job title, then you can't compare them. It also allows for to be compared if they don't work at the same establishment, and I think that that's something that potentially the OCCP, if they have multiple cases going on, could look to. And then it also requires employers to justify pay differentials. It really limits the factors that employers can use to justify those differences. So I think it's just something that we need to keep our eye on. We'll see for sure when the guidelines are released, and I'm sure there will be multiple blog posts, webinars, articles about the impact of that. So at this point, it's really important for you to just keep that in mind. And I think one of the themes that you're going to see throughout my presentation is relating to compensation. Clearly, that is where the OFCCP's time, effort is being spent, and we'll see that throughout their goals. We have is the Equal Pay Report, and so this was in the final rule stage, although I have here that it's on hold given EEOC's recent proposed revisions to the E1 report to include pay data, so I would go a little step stronger and say that it's essentially dead. You know, the E1 report revisions that the EEOC has recently proposed sort of takes that, takes it on that, and OFCCP is really going to then just be following EEOC and using the data that they are going to be collecting. So they did indicate that they're not trying to have both of these proposals go through. I will say for this Equal Pay Report, I'm going to kind of go through it pretty briefly. I know I sat in last week that John Fox had done I think it was an hour-and-a-half webinar specifically on the Equal Pay Report, and I think those of you, if you were on the call on the webinar and you are a member, you can access that through the pipeline, but again, he went into a lot more detail that I'm going to go into. But the proposed changes were published on February 1st, and comments are due by April 1st. And really are as part of, and we'll talk a little bit more about the sections where they're looking for more feedback, but there are a lot of places where employers need to be providing feedback, and we'll talk about how to do that and the best way to provide that feedback. They are really looking to implement these changes for 2017 filing cycle. So Even though, we are in 16, they are looking to potentially finalize these changes in this year and then have you file that way in 2017. The proposed EEO-1 report revisions really has two components. So component one collects the same data that is gathered by the currently approved form, specifically data about employees' ethnicity, race, and sex by job category. And that is currently being filed by everybody. And so the proposed report essentially says those companies, even if you are a federal contractor and you only have 50 to 99 employees, you only are required to submit for component one. And then component two, which is the expanded version, will collect data on employees' W-2 earnings and total hours worked by 12 pay bands in each EEO-1 category. So this greatly increases the amount of information that is going to be collected by the EEOC. And figured the best way to sort of walk through this, and I know it's quite on the screen, but you can get to this through the EEOC's they have information page on the EEO report revisions where you can actually click through and see what the proposed report looks like. But here you can see this is the section on employment data, and as you can see, you have all the information specifically. This is just for executive senior levels. It's broken out by all of the different salary bands and have the different race. You have your ethnicity, and then for males you have race, and females you have race, and then you have your total columns. So again, they're looking for you to report if you have a Hispanic female executive who is making $115,000 in their W-2, they would be going up here, under the female column. So this information, they're looking to collect this on, and a little bit about what that means for W-2 wages. Looking at this information as part of your EEO-1 using that same population. So then the next group of employment data would be the hours worked. And so for each cell, they're looking for you to provide the total number of hours worked in the last year. So in the example I gave, if you have a Hispanic female and she was there for the full year, well, she's an executive, so she's exempt. So I'm sure she worked more than 80 hours, but you're going to have to put something there. And so most likely if you had one employee who was full-time exempt, you would be reporting the 2080 in that female column for hours worked. So this is the way the EEOC is looking to collect the expanded information related to pay on the EEO-1 report. So this greatly expands the option of contracts, which next slide really is the irony of it all. I think for me, in looking at this, the burden hours that they have associated with this are grossly underrepresented. What they did is they changed the way in which they have identified the burden hours. So what they reported is that most employers were now electronically. So that I'm assuming means they're either hand inputting into the existing website or they are generating a file from their HRIS system, which then they're uploading into the EEOC site. I think the piece that, is frustrating for me is the fact that I don't think I have any idea how much time it takes employers to actually go through and to not to collect, but to verify and validate this data. I think that they think that you just go into your HRS system, you press a button, it generates a file, a perfectly clean file. You just go over to the EEOC site, you upload it, and then everything turns out perfectly. And so that has not been my experience with most employers. There's a lot of work that has to be done in verifying and validating and fixing any underlying data in the system. It's always important and I think that's a piece that the EEOC just really does not understand. I also find it ironic is now that they are doing burden hours by filer. So what this means is they're saying that the average is 6.6 hours. So that they're saying that they expect it would take a 150-person company the same amount of time that it would potentially take a company that has over 200,000 employers. And I think that is not the right way to be handling this. I think that there is a huge difference. We know it. We file E1 reports for close to 200 clients every year, and no question, the larger the client is, the more time it takes to go through this process. And so I think by them not, I think before the burden hours used to be by report filed, not necessarily by filer. So I think that is something that comments really need to focus on, need to actually go in and if you have the time to say, okay, how long would it take me to get this information and be able to report on it? I think that they really need to understand how burdensome this is going to be, and so that they can evaluate if what they're actually going to be getting from this is going to be something that's worthwhile. So these burden hours are really associated with once the data is all there. I also felt like the proposal lacked a clear understanding of the differences between ARS and payroll systems, the reporting of W-2 wages and total hours worked. I think that there's this belief, again, that you can go in and you can press a button and then you're going to get this report. And that has not been what I've seen in my experience in working with clients and gathering this information, particularly as it relates to, the gathering of W-2 wages. Those are all things that I think people need to comment on, whether or not, if you don't feel comfortable with the company commenting yourself, if you actually want to go to an association or to your vendor and provide your comments through them, that's also another option, but we definitely encourage people to go forward and please try and provide as much feedback as possible. They did specifically ask for feedback on what to do about total hours worked for exempt employees. So there's no requirement for exempt employees to track their hours, and so the question then comes in, well, how am I going to then provide that information? And so for those of you that are wondering, well, why do they care about total hours worked? I think the reason that they need that is particularly since they're asking for W-2 wages. So, for example, if you have somebody that worked a full year, their hours worked will represent that. If you have somebody who only worked a few months as part of that prior 12 months, their payroll date, then that will also show in the total hours worked. So that's one of the reasons that they have to be collecting something to show that difference, to show what it is. Whereas if you were to say for all your employees just report their annualized their salary as if they were working 40 hours, then that would put in a position where you could say everybody would be on an equal playing field. So again, this is just something that's more information to come, and so be on the lookout for that. And as I mentioned, John Fox had done an hour-and-a-half presentation on this. If you're looking for more substance, definitely recommend you listen into that recorded webinar. The construction contractor requirements, those have also not been updated since 1980. And those of you who say, gosh, this sounds very familiar, it should. These have been on the agenda since the fall of 2009, and they basically have just been putting on each 6-month regulatory agenda with a proposed end date of the last month of the next one, of when they're going to release the next list. So this proposed rule stage, they're saying that they expect it to be published in May 2016. It doesn't seem like this has been a priority for the agency, and so I'm not sure where this is on the list of things that they feel are really important to get done, considering it's been over since they've actually, or 7 years since they've actually put anything out there. So again, if you're a construction contractor, I don't have any answers for you as to when that will come into play. things that were not particularly on the OCCP's agenda, but do affect federal contractors that I want to make you aware of, is you have Executive Order 13706. That was signed by President Obama in September of 2015, and the rule is currently in the proposed rule stage. So the Department of Labor's fall 2015 regulatory agenda indicates the proposed regulation will be published in February, so this month, with a goal of being finalized by the end of September of 2016. So if it is enacted in that time frame, the rule would most likely cover federal contracts or subcontracts entered into or modified after January 1, 2017. Proposed terms would require cover federal contractors and subcontractors to provide employees a minimum of 1 hour of paid sick leave for every 30 hours worked, a minimum of 56 hours of paid sick leave per year. Contractors would be required to provide employees with unlimited carryover sick leave each year, as well as reinstate prior sick leave back to employees hired with 12 months of separation. It also states that accrued unused sick leave does not have to be paid out at termination. So at this point, again, it's in the proposed rule stage, focus on providing comments and feedback to the government. At this point, really not a whole lot that you can do to prepare for it. It's just a matter of keeping an eye out for it. I think one of the main things that I've heard about this from a lot of contractors is that they don't have quote-unquote sick leave anymore. They have a combination. They've combined the sick leave with their vacation leave or personal time off, so they just have a leave bank. And so the challenge will then be how do they make sure that they can comply with this and potentially keep that, or do they now have to break out their days and show them specifically as sick leave? So that's what I'm hearing, and from our clients and from other people, is that's one of the main concerns that they have with this implementation of this executive order. So the executive order that we'll go ahead and talk about are what we call 13673, which generally in the industry have been called the blacklisting regulations. And so this requires, I realize on my slide, I'm going to go forward before I go, and then I'll come back and talk a little bit about where this stands. So this requires federal contracting officials to consider self-reported federal and state labor law violations from the past 3 years when determining whether a bidder for a federal contract of $500,000 or more has a satisfactory record of integrity and business ethics. And so it also requires federal contractors and subcontractors provide workers on covered contracts with information each pay period about how their pay is calculated and notice to those deemed independent contractors. And it also, for contractors with covered contracts of $1 million or more, are banned from requiring workers to agree mandatory pre-dispute arbitration for claims under Title VII or torts relating to sexual harassment or assault. So I think the biggest thing comes from this is, what does this mean for federal contractors? So on May 27th of 2015, the DOL proposed guidance, and the Federal Acquisition Regulatory, the FAR Council, also issued proposed rules. And so for this, it still remains in the proposed stage, but I think one of the most interesting things that did happen with this was related to the budget. So in fiscal year 16 budget, the administration requested $2.62 million to create a new DOL office of labor compliance that, under this executive order, would play a major role in reviewing contractor labor violations and determining whether they were serious enough to be used in making determinations about a contractor. Now, that request was denied by Congress, and here's the exact language. It says the administration requested $2.62 million and 15 full-time staff to initiate an Office of Labor Compliance. This request denied by the agreement. No funds in the bill have been provided for this purpose, but it also included language making clear the Department of Labor, quote, shall follow the directions set forth in this act and the accompanying statement and shall not reallocate resources or reorganize activities except provided herein. So basically they're saying, look, we're not giving you the money to actually do anything with these regulations. I think again, coming from a contractor standpoint, what I'm hearing the most people concerned about is saying, does that mean I can sign a conciliation agreement that could be used against me, that would be viewed, as a sort of as a blacklisting, right? So what extent, what sort of violations are they considering as part of these regulations? And I think that right now is the biggest unknown for contractors, but it is something that you need to be thinking about. How does that impact your risk management strategy, regarding decisions about current enforcement activities that have to be reported in future procurement bids. So again, I think a lot of people are thinking about, sometimes you sign a conciliation agreement not because you think you did anything wrong, but because you want the audit to go away. And I think contractors are having to really start to rethink strategy. If it's, if they're not asking for any reporting or it's not requiring any money, sign it and make it go away. And I think some people are looking to, they're questioning that approach now, particularly with these regulations. So that's something to consider moving forward. Some executive orders that came through that have already been into effect. So those are things that are not new, things that you should know about. The Executive Order 13762 went into effect on April 8th, 2015. So prohibits federal contractors from discriminating against employees on the basis of sexual orientation or gender identity. So the takeaway from this is EEO policies and other documents that reference protected bases should be updated to include sexual orientation and gender identity. I don't know about you, but how many others are really tired of updating your EEO statement of policy? Every time my clients, we finally get them they get one signed, and then we call them back and say, hey, we have to add something new to that. It feels like we've been updating that document quite a bit the last couple of years. Contractors also need to ensure that they've posted the OFCCP supplement to the EEO as the law poster. So that supplement is out, and we're also going to talk about the supplement as it relates to pay transparency. So that will cover both the gender identity and the pay transparency requirements. So it's important for you to make sure that, whatever posters you have up, eventually until they create a new poster, you have to use these supplements in addition to the EEO's law poster. So Order 13665, so pay transparency, that actually just went into effect a little less than a month ago, January 11th, 2016. Again, this is where you sort of run into some of these questions where you say, well, it applies to covered federal contracts that are entered into or modified on or after that date. So that's always a challenge when you're looking at this. I think contractors, need to update their policies and their practices and not worry about, I'm going to say this as employee because I don't think we've had a contract, modified as of January 11th. So therefore, I'm allowed to tell my employee that they can't talk about pay. So I definitely don't recommend getting into semantics and having, your procurement officials go and look up, when your last contract was signed. But essentially, this executive order prohibits contractors from taking adverse action against certain applicants or employees because they inquire about, discuss, or disclose their own compensation or the compensation of another employee or an applicant. So this one, I know, again, this is another topic that we could spend an hour and a half alone on it in terms of having discussions about what does it mean to, what exactly does it mean to talk about compensation. Particularly, most of the conversation is talking about the inquiries, discussions, or disclosures of compensation information that employees obtain through their essential job functions are not protected. And so I've just heard a lot of talk, a lot of scenarios. Well, what about this situation, or what about that situation? Or so unfortunately, where we are right now is we don't, until CCP starts to act upon this, it's going to be difficult to say where that line is drawn. But eventually, you have to think about who has access to that information and really evaluate whether or not that is something that needs to be Do they have to have access to that information? And have to think very strongly, or to think thoughtfully, if you have somebody who has access to that information, you're assuming that it's their essential, and they release that information to other people, you really need to evaluate whether or not it was part of the central job functions of having that information. So again, more detail in terms of the inquiries. So if information is obtained as so I'll just read this verbatim. Information is obtained as a part of employees' essential job functions when A, they access to compensation information is necessary to perform that function or another routinely assigned business task, or two, the function or duties of the position include protecting and maintaining the privacy of employee personnel records, including compensation information. So I know some good conversations that we've had where people have said, hey, we have, admin assistant of a hiring manager might send out the offer letter. And, that might be something they might do 3 or 4 times a year if their manager hires somebody. Is that information protected? Is that an essential function of their job? And people are just starting to rethink, okay, where is all the compensation information held? Who has it? And making sure that, that is a necessary part of their job. It's also important to note that employees with job functions are protected to the extent that they are allowed to discuss their own compensation with employees, and they can discuss possible disparities involving other employees' compensation with a management official or while using the contractor's internal complaint procedures, or disclose and discuss the compensation of applicants or employees in response to a formal complaint or charge, investigation, proceeding, hearing, or action. So again, I think there's more information is part of this act, but it's also important for you to understand that, there are some protections for you. So one of the examples that we have written up is, there is a defense for contractors in the event that compensation inquiries are made while violating a consistently and uniformly applied workplace rule, so long as that rule doesn't generally prohibit compensation disclosure. So the example we give is kind of a little bit of an outrageous one, and may have a rule that prohibits employees from being disruptive in the workplace. An employee may violate that rule by standing on his desk and repeatedly and disruptively shouting out his pay. In this case, the employee may be disciplined for those actions. You were disciplined for being disruptive and not for disclosing his pay, as long as the employer consistently and uniformly applied the workplace rule. So you can have somebody, standing up on their desk screaming, out loud that they're really excited that the Broncos won the Super Bowl, and if you don't discipline that person, then you can't also discipline the person who stands up and yells out their pay. So there are some protections in there for employers, but it's really important for you to sort of understand that. And I think the biggest takeaway from this is really understanding what your, who has access to pay. Again, once you become covered by these regulations, so you must incorporate the specific non-discrimination statement as prescribed by OCCP into your handbook. You have to share the statement with employees and applicants through electronic or physical postings. The supplement covers it. You don't have to make, as long as you're having the E-clause by reference in your subcontracts and purchase orders, it's fine to keep it in there. But again, this was another example where we'll go in and update our policies and procedures for a second time, in recent months to get that done. So, some other additional updates that came through in terms of Executive Order 13658. That was signed in February 2014. So it was signed, and this one was, I think everybody sort of freaked out when this was initially released, and then as we sort of learned more, it became clear that it wasn't as broad as people thought. When it first came out, it sort of made it seem like every federal contract had to have a minimum wage of $10.10. That was not the case. It's really specifically tied to those federal construction and service contracts had to be paid a certain minimum wage. And to be honest, I think most were being paid the wage through the Service Contracts Act anyway. But so that actually, in January 2016, that did increase to $10.15 per hour and $5.85 per hour for tipped employees. So just to make you aware of that update. Another update that came through is with the adjustment to the dollar threshold for VEVRA in Section 503. So actually in 2010, it did change from $10,000 to $15,000 for 503. And then in 2015, a similar adjustment to VEVRA was made, increasing it from $100,000 to $150,000. So OFCCP did adopt the FAR Council's adjustment thresholds for determining whether a contractor is covered by Section 503 and VEVRA. Here, the interesting thing on that is that is for VEVRA, it'd go up. So you would not have to, if you had a contract of $110,000, you would not have to do an AAP for protected veterans. However, the VET's 4212 report is not tied to the adjusted thresholds, and that still remains at $100,000. So you very likely could still be required to file a VET's 4012 report, but not actually go ahead and have to file do an affirmative action plan for protected veterans. So just an interesting tidbit on that. So the impact of the election year on federal contractors, I think, for this right now, obviously we've had a caucus and we've had a primary, and we've had different winners on each. But obviously we know one thing, there is going to be a change in office, and it really could greatly impact federal contractors. I think most people understand the fact that if a Democratic administration stays in place, we would expect to see very similar, we would expect the OFCCP and these other Department of Labor initiatives to stay the course. We aren't anticipating that there will be a major turnaround or major differences in sort of anything that the Obama administration is focusing on that a Sanders or Clinton administration would not focus on. Obviously, if Republicans come into office, that would be a completely different story. And I think with the Republicans, you certainly have a much broader realm of beliefs, and so we really don't know until that group starts to well down to really understand what the impact would be on full contractors and on some of these initiatives. And so we are expecting the current administration, they really want to finalize any of its proposed rules by the end of November. And that would be particularly if a new administration were to take office, and that's because a new party. It is anything that's not finalized by the end of November would have a period by which that they could sort of turn it off when their administration starts. So it would be important for the administration. They are definitely paying attention to the election. They're definitely paying attention to what's going on. And I believe some of that is what's putting the EEOC come out with the proposed pay report quickly. It seemed, from some of our reading of the work that they were doing based on the National Academy of Sciences study, it seemed like they were taking their time, and then it seemed like they went really quickly. And we have a feeling that had come through specifically for the administration had pushed that through. So again, we do expect activity as they attempt to complete outstanding proposed regulations and rules, get things in order, so whatever new administration comes in, that they can sort of follow through on what the Obama administration had started. So predicts for 2016 compensation. So if you hadn't realized that throughout this entire presentation, that seems to be what the focus is. We are seeing it in all of our audits, that continues to be the primary focus. They are asking for compensation policy reviews. They are asking for interviewing compensation managers, focusing on starting pay, asking questions about starting pay, other types of compensation such as bonuses, commissions, and overtime. So I think it's very important that contractors are prepared for that. I think that's the one thing that when you get that audit letter, it's so important for you to understand, who the CCP might want to talk to, the impact of what that person is going to say about your compensation policies. The compensation manager needs to understand, what they tell the OFCCP is then going to try and replicate. So, my favorite one is, of course, everybody wants to say what we pay for performance. And so everybody says it, and I'm sorry to tell you this, but most likely your data does not do that. And so inevitably the OFCCP will say, okay, well, if performance dictates compensation, then we need to look at your performance data. And then all of a sudden it's like, oh, well, we don't have that electronically. And then you start looking at it and saying, oh, managers don't see that before they make compensation decisions. So ACT does actually predict pay. They're all important things that you need to be prepared for. Unfortunately, I have seen, what I can tell you from what we've seen is those contractors that come into this prepared, they've analyzed their data, they're comfortable with any discrepancies that they have, they can expect them. They can generally be successful in defending these cases. Companies that take the wait-and-see attitude, well, let me just wait and see what they ask for, then they're scrambling at the end, and then they're not prepared as part of these interviews, as part of these policy reviews, and the OFCCP is able to find things and ask questions that perhaps had they been more prepared, they wouldn't have had to answer. So, and continue to focus on compensation, make sure you understand what data is that you're providing the OFCCP, and making sure that it's accurate. I know that they've asked for bonuses, commissions, and overtime, and that was sort of the big hubbub when the new letter came out. We haven't really seen that much questioning going on with that, interestingly enough. We've gotten some, but that has not been, my surprise, as much of a focus from the OFCCP as comp as I was expecting it to be, but that doesn't mean it won't in the future. Continue to see the focus on personal activity. So then any time that you have any adverse impact that is statistically significant, anything with shortfalls, large shortfalls, they definitely start asking questions and want to dig deeper into that data. We always recommend dig deep before you dig deep, because then other questions always come through. What the news is, we have seen less reliance on, there used to be this standardized technical questions that were being asked regularly. It was about the first part of last year, and it was brutal. I mean, it was all of these questions, and they were being sent, and you were having to sort of put through a lot of the details, some of which were already in your AAP, and having to take those separately. We're seeing less reliance on that, and I don't know if that's because the contractor community stood up and started questioning why everybody was getting the same questions. That hasn't gone on B. But it seems there's less reliance on that. But we are also seeing an uptick in the review of compliance with protected veteran and IWD requirements. And again, I think this is for two reasons. I think it's because now that you're in the full year, have more teeth and sort of requirements. And I think just like anything else, the CCP is getting more comfortable with it. So the officers are seeing more plans with it. They're seeing, different ways people present the information. And this is, something I always say is you always have that, that person out there that really tries to go above and beyond. and then all of a sudden they go, oh, I like the way they did that. I like all the extra things that they did. And they sort of raised the bar for everybody else. And so those are things that, okay, now that the OFCCP has done 20 audits, we've seen the written evaluation, they not be comparing you now to what's expected. They might be comparing you to what they've seen others do. Again, it's not what they're supposed to be doing, but I think that's a natural thing to say, oh, gosh, well, compared to these other audits I got, they're not looking to see does your evaluation actually meet the requirements. They're saying, well, your evaluation isn't as good as everybody else's. And that's just something to consider. They're just having more of those that they're seeing during this time. So those are the different things that I anticipate the OFCCP will focus on for 2016. Do want to say that in conclusion, one of the things that they will be hampered by is they actually had a budget decrease. And so that is not particularly common, and I think it was sort of a little bit of a slap on the wrist to the OFCCP to have that happen. So it wasn't just that a lot of times you put in for an incremental increase didn't get any increase. They didn't even get current funding. I believe they came in about $1 million under current funding, if I'm remembering correctly. So, that is a challenge for them. They are not going to be able to fill positions that are currently open, and so I think it will hamper them. I know that they've been struggling as it relates to scheduling audits. They did a lot less audits in 2015. I don't anticipate how it's possible that number can go up. From our understanding, I know at least we had a local Baltimore ILG meeting yesterday. They are still scheduling off of the list that they received in the fall of 2014. And so they still have people on that list. They're still auditing. So we are anticipating at some point in the near future that they will be issuing a new list. We've heard some smatterings of it this week, but we have not seen it. If you are studying and you did get an audit letter for a location that wasn't on a previous list, certainly send me an email, let me know. But we are anticipating that they should be coming out with a new list. We're thinking some offices may be getting lower inventory. Again, it's going to be an eventful year. So other things is, just kind of don't forget. I know once we had the protected veteran and IWD regulations, you went in and everybody did a great job of getting everything set up and moving forward, but don't forget there's ongoing responsibilities with that. So just because you're now collecting your applicants and your hires who are veterans and individual disabilities, you've got to be looking at your recruitment sources. You've got to be determining whether or not they are bringing in the appropriate number of applicants for you, whether or not your efforts are gleaning results. The OCCP really is expecting you to be making changes if those aren't working. And again, continue to focus on compensation in areas of adverse impact. So you really, need to, I know it's sort of be here as an affirmative action plan vendor, but it's really important when you're, if you do your own AAP or a vendor does your own AAP, you really need to be understanding what the impact of that is, any issues that you have. I will tell you that 30 days from the time audit letter to the time you have to submit, it's never 30 days because the letter never ends up on my desk. It's just not a lot of time, and so I think that you really need to be looking at your AAPs once they're completed, ensuring that you understand any compensation issues, any areas of significant adverse impact, and making sure you're prepared for that. So that is it. So that ends the presentation. So we do some time for some questions.
Okay. Thanks, Beth. I think that you provided a whole lot of really good information, and we have a whole lot of questions. So,
okay.
First of all, and I just because we have so many, I hope you don't mind. I mean, some of them I can probably knock off pretty quickly. A lot of them have to do with the EEO-1 proposal to revise that report. And Beth, I'm just going to ask you because I think 3 or 4 questions had the same subject. One question was proposed changes to the EEO report also apply to EEO-6, correct? Go ahead.
No. So there is not an EEO-6 report any longer. I know, so that's specifically for universities. So I know that they have to do an IPEDS report. That's an interesting question because typically universities have not been doing EEO-1 reports. Obviously, OCCP has been reviewing them and not requiring them to submit EEO-1 reports. So at this point, this is one of those situations where I would say don't ask the question because you might not like the answer. But I would say if you're currently not doing an EEO-1, the expectation wouldn't be unless you were specifically told that you had to start doing one. And again, I caution universities on being too proactive in asking that question because you may open up the lion's den.
And that's how we started, honestly. We started our webinar last week saying the exact same thing. Don't expect that it might happen, but right now it says a proposed revision to the EEO-1. So I give you some good advice. Are they looking to include fringe benefits in the W-2 wages?
So it would be anything that's good. So I'm not a payroll specialist, so I can't tell you everything that gets included in W-2. But the expectation would be if that's included as part of your W-2, that would be something that would get recorded for these purposes.
And I agree. And we had another question about do employers subtract out pre-tax items, HSA, FSA, and that sort of thing. And I will tell you, whatever's in your W-2, whatever your company does, right now, all they're saying is W-2 earnings. Now, we did have a good question last week, is, which box?
Right.
And nobody knows. So what I recommend is that you send the comments in. I know Direct Employers is going to do comments, so you're welcome to forward your questions and concerns to me. Beth, I don't know if you guys
we're going to do comments as well.
That's really, really important stuff to get out there because that does need some clarification. So here's a good question. What do you think about having your congressman comment on the EO1 burden?
I think that's a great, I honestly believe that contractors need to use every resource in their book to try and get through to the EEOC. And so I definitely recommend, now I will say there probably will be some sort of education that needs to go on at the political level, but I certainly encourage companies to do that. I know we are members of, Berkshire is a member of the Chamber of Commerce. I know they're doing a lot to try to gather information their constituency to then provide comments to the EEOC, and they are certainly encouraging their members to reach out to their government officials to educate them on what this means. I also believe there's going to be a session, a public, and it's not a hearing. I believe it's just like a public statement sessions that they're going to have where people can go in and talk about, anything related to the proposal. And so we're, that's all we can do is sort of try and educate and, if we have, media or whatever we can do to sort of talk through. So for me, what I feel most passionate about is that burden. I think that it's not fair to try and put something forth with a true calculation of its costs. Not saying that, they really do a true cost-benefit analysis. Does the benefit of what they're saying they're going to get from this? And let's not forget, we had the EO survey that we had out there years and years ago, and that was proved to show no benefit and no predictor of issues in terms of trying to choose people for audit. So, is extra burden really going to give them what they're expecting? And my gut feeling is absolutely not. The amount of work that it's going to require companies to do to comply with this is going to far outweigh any sort of analysis that they're going to be able to glean from these reports.
And I really agree with you, Beth.
Not that I'm opinionated on it or anything.
Yeah, let us tell you how we really feel. Okay, we actually have a few questions on paid sick leave, and one person wanted to know, can you please discuss which federal contractors would be required to offer paid sick leave? And then one is, repeat again, does unused paid sick leave have to be paid out if the employee leaves the company?
So, so the rule states that accrued unused leave would not have to be paid out at termination. And so for the other question, I will have to get with you to say I'm not sure if it's limited to a certain number of contracts. I would have to get back to you on that. That one I'm not. I don't have all of the, as I mentioned, I'm not an attorney, so I don't have all of those details, stuff in my brain. So I have to go back and relook at the paid sick leave and say, is it specific to certain types of contracts, or is it just if you are a federal contractor? But I can certainly, I know we've done write-up on it. I just need to go back and reread those. But I can answer on that one.
Okay, thank you. Comment, just a reminder from someone, they said on the OFCCP webinar that they want the pay transparency non-discrimination provision to also be posted. So I'm going to throw that out. I don't know if it was mentioned or not. So there's a few questions about, you mentioned the annual written outreach and recruitment evaluation. Since you work with employers, affirmative action plans, what are they including in their evaluations, and exactly what is the OFCCP focusing on? And then someone else wanted to know if you have a template for the annual written outreach and recruitment evaluation. Real quick, I'm going to say I do for the direct employers folks, so if you are a direct employers member, feel free to contact me, and Beth, I'll let you handle the rest.
Yeah, I am pretty sure we do also have a template for that, so I would have to double check with my team to make sure. And we do have, for our clients, we recently created a portal, so this would encourage you to access that portal and go in the resources section where we have all of that information out there. I think from, I don't want to give people false hope and say that I think some of the submissions that we've done this past year on a full AAP for the written outreach have been what I would call light, and they've been accepted. But I think part of that is just because it was new. So we have not gotten a lot of pushback on our clients' written, but I would say from my assessment, some of it was really good, some of it was weak, and we literally got no questions on either the really good one or the really weak one. But at this point, I don't have a way to say, hey, this is definitely not going to work or this is going to work, because so far everything we've submitted has been accepted. Like I said, that it can only be as good as what the client has done. We've literally been in situations where the client was like, what? I was supposed to be doing this? We've sort of had to recreate it, and others where the client was on top of it. And so, but again, I don't want to say acceptance of what I would consider a fairly weak evaluation is going to continue. I think it's only going to be more scrutinized.
And I think, Beth, you said earlier on in the webinar, and I agree with you on this, it's all about presentation. So if you have a good and it's well thought out and well prepared, that goes a long way in their review of it, I believe. So
I even say, even to direct employer members, I think one of the things that was interesting, we had two plans, and this was a while ago, where a client had in one instance basically sold out. We use direct employers, and they post all of our positions on all of these things. And then I had another, we said, don't do that. Just say, hey, our jobs are posted all these places. It's all how you present it. And I think what direct employers does is great, but you don't have to tell them that direct employers is doing it for you.
Exactly. We do it for you. You go to sleep at night. You don't have to worry about it, right?
Right.
Okay, so I know the person that wrote this question, and I'm going to tease you at Dean, but it has been nearly one full year. If it has been nearly one full year since you last responded to the last supplemental data request, are you better off leaving that sleeping dog alone or follow up with the compliance officer for an update where things stand? Don't ever call her.
I go back and forth on that, because it definitely depends on the time of year. We were actually quite successful in the July, beginning August, September time frame of getting some things really just closed out.
Well, that's true. I would end of their quarter or end of their fiscal year, right?
Yeah, and I think if you honestly look at your information and you feel confident that you don't have issues that are going to come into play, sometimes it can be successful to call up and say, hey, I feel like we are moving along here. Tell me what is planned for this. Where is this? Where is it going? Sometimes it might lead to a looking at it and getting it focused on. But that's honestly, everybody has sort of their own take on it. If I have a client whose data looked really bad and they had bad adverse impact, and I might say, well, maybe we don't. Maybe we do let that sleeping dog lie. But if if your submission looked good and you feel like you have a strong leg to stand on, it might not hurt to just say, hey, I just want to understand, where this stands.
And that is a good point. I think that's probably a good qualifier. So if you're in good shape, yeah, go for it. But if they're looking at compensation data and requiring you to provide information, I would just sit quietly.
Yeah. Remember, they can't audit you while you have a current audit going on, so it only puts that location on the not audit list for that much longer. So, and the benefit of keeping it open.
Exactly. Okay, so since it is a requirement for employers to provide data on vets and disabilities, should companies no longer make that question on their application an option to complete? Should the form be a requirement?
So, I'm sorry, repeat that question again?
I'm assuming it's a self-identification form because it says since it's a requirement for employers to provide data on vets and disabilities, should companies no longer make that question on their application an option to complete? Should the form be a requirement? So the only form I'm thinking is that it would be the self-identification form, and it's a requirement that you present it, but it's not a
right. It's some companies require you to, so they might give an option and say where the options, and then one option is I choose not to identify. So I do know that some people do make it a requirement to actually an option. As long as you have an option that says I choose not to identify, I think that's fine. So you have to put something in there, but again, you can't. You give them the option of just yes and no. It has to be the option to say I choose not to identify.
Okay. Yeah, I think that's where that question was going. So, last question, and this is a good one. Do we have to include the term gender identity? Oh, not the last one. We just got another one. In our EEO policy, or would any other basis protected by applicable discrimination laws cover this requirement?
I know we broke it out, and so our Len, who is our director of regulatory affairs, who used to work at the OCCP, wrote it. So I'm going to go with her and say she probably would not have spelled it out had we not been required to. I believe it. I can double check on that, but I'm pretty sure it needs to be spelled out.
Well, and you know what, Beth, I agree with you. The direction we've been providing is that anytime you use like a paragraph form in your EO statement in your state or tagline, if you use the word sex, you have to include sexual orientation and gender. So I think we're on the same page there. So I have missed this. Was there any update on the proposed FLSA salary threshold increase for non-exempt employees? No, and Jiminy Christmas, God help us.
Yeah, no, I actually was I'm on a board of a nonprofit, and they are completely freaking out. And so it's funny because they just asked me about that the other day, and I was reading an article that indicated that, again, that is something that they are looking to come out with in 2016. So that will be another big, game changer for a lot of employers.
Well, you know what? I just sent a lot of information to my daughter. She's a head athletic trainer, and she's got people that report up to her, and she was very concerned about it for the university and for the department. And I was on a webinar yesterday, and they talked about receiving over 300,000 comments for that proposed rule. So I told my own daughter just to sit tight because I said as early as May or as late as July, but I think that's really pushing it. So that's really all I know about it. But
yeah, and I would say probably out of that 300, there's a lot of saw this I think with some of the other proposals that were out there. There are a lot of associations that create a form letter. They send it to their membership.
Yeah,
and
then
true. they have their members submit the form letter. So I think probably a lot of that is those form letters. It's certainly ones that they consider. So
the only hope I think that we have is I remember after the Veteran 503 regs went into effect in March 2014. I remember when they talked about linkages and all of the other things that we were all concerned about. When the final regs came out, I said they were basically a walk in the park compared to what the proposal showed. So I doubt if they're going to more than double the salary threshold. That's pretty drastic. So, and especially all the nonprofits threatening to go out of business, I think that could be a real concern. So, and we did a little bit over. Beth, you get all of the questions answered, and I want to thank you again. Some great information, and I think we had a huge audience, and hopefully we got any audio issues taken care of. So I'm sure we'll probably be able to talk Beth into another webinar sometime soon. And I hope all of you look at our own website at Direct Employers and consider attending our DEEM 16 conference in May. With that, thank you again for participating, and hope you have a great day.
Thank you very much.
Beth.